A person who acts as a director of a credit union is exposed to the possibility of personal liability. Directors have good reason to be concerned about liability exposure. However, directors should be able to mitigate the risk by exercising proper due diligence, fulfilling their duties, and ensuring that proper indemnification provisions and insurance are in place. It is not the case that a credit union director is automatically liable for anything the credit union does wrong. In general, the director must have authorized, permitted, or acquiesced in the course of conduct that leads to liability in order to be personally liable. Normally, if the director can show that he or she exercised reasonable due diligence, the director will not be held personally liable for the conduct of the credit union. A credit union director could be held personally liable for failing to meet his or her fiduciary duty or duty of care, diligence, and skill. The most obvious example of a failure to meet these duties would be in the case of fraud or misappropriation of funds, but also failing to meet the required standard of care of a credit union director could result in personal liability. Credit union legislation provides that directors will be personally liable if the directors vote to approve a resolution that authorizes certainly specifically listed acts or conduct. A director who is not at the meeting at which the conduct was approved or who dissented in the decision should provide a written dissent on the decision to the credit union secretary. There are also numerous other statutes which provide for the possibility of personal liability of directors. These include employment standards legislation, health and safety, environmental legislation, among a long list of other statutes. Some of the legislation will absolve the director from liability if the director has exercised due diligence, while others do not provide a due diligence defense. A director should make sure that the bylaws or rules contain provisions for the indemnification of directors. Alternatively, directors could obtain a separate indemnity agreement from the credit union. And of course, it is important to ensure that the credit union has appropriate directors and officers liability insurance in place. It would be advisable for a director to obtain a copy of the policy in order to understand the coverages and the exclusions and to ensure that the policy is updated on an annual basis.